Do you feel picked on because you're older than your coworkers? Do you suspect you lost your job because you're older and because you made more money than younger workers? Age discrimination is a common complaint. A recent survey for AARP reported 64% of respondents thought that people older than 50 face age discrimination in the workplace. Some 34% said they had either personally faced age discrimination in the last 4 years or they know someone who has. The impact of age discrimination is more than just financial. Older workers who think they are discriminated against are always so angry and hurt. Their personal identity is tied up in their jobs. But feeling like a victim of age discrimination and being able to prove it are two very different things. Proving age discrimination has never been easy, but in 2009, a U.S. Supreme Court ruling made it even more difficult. In the 2009 Gross versus FBL Financial Services case, the court changed the rules. Supreme Court Justice Clarence Thomas, a former Monsanto corporate lawyer, wrote in the majority decision that the employer doesn't have to show it would have taken action, regardless of age, even when an employee has evidence that age was a motivating factor in that decision. New legislation that would change burden of proof and causation standards for a number of employment discrimination claims was reintroduced in the House and Senate in July 2013. The Protecting Older Workers Against Discrimination Act would overturn two Supreme Court decisions that toughened the burdens of proof for employees bringing discrimination claims under the Age Discrimination in Employment Act or advancing retaliation claims under Title VII of the Civil Rights Act. In reversing Gross, the Protecting Older Workers Against Discrimination Act would establish that when an employee shows discrimination was a motivating factor behind a decision, the burden shifts back to the employer to show it complied with the law. In essence, a plaintiff bringing a claim under the ADEA would not be required to demonstrate that age was the sole cause of the contested employment practice. In a more recent Supreme Court decision, University of Texas Southwestern Medical Center versus Nassar, the court held that Title VII retaliation claims must be proved using a but-for causation standard as well. Under the standard of causation adopted in Nassar, a claimant must prove that the unlawful retaliation would not have occurred in the absence of the alleged wrongful action or actions of the employer. The Protecting Older Workers Against Discrimination Act would provide that the more lenient motivating factor standard would apply not just to ADEA claims, but also to retaliation claims involving race, sex, national origin, and religion, as well as claims brought under the Americans with Disability Act and the Rehabilitation Act of 1973. In a press release, Senator Patrick Leahy, one of the Senate bill's co-sponsors, said, "The Supreme Court's divisive holding in Gross has created uncertainty in our civil rights laws, making it incumbent on Congress to clarify our intent and the statutory protections that all hardworking Americans deserve. Our bipartisan bill reestablishes Congress's intent that age discrimination is unlawful, and it makes clear that employers cannot get away with age discrimination by simply coming up with a reason to terminate an employee that sounds less controversial." The older generation, those born from 1946 to 1964, account for the fastest growing segment of workplace discrimination claims. In 2012, 22,875 people filed age claims with the Federal Equal Employment Opportunity Commission, compared with 15,875 in 1997. Employers may think they can get rid of older workers and bring in younger, less experienced workers to save money without realizing that could constitute age discrimination.
Today, the Insider exclusive Investigative News team goes behind the headlines in You're Old and You're Fired, Harold Cunningham and Alex Pennington's story. To examine how Teresa Cunningham at the law offices of Teresa Cunningham successfully won a wrongful termination case for her clients, which sent a message to the public and employers that older, more experienced employees and members of society should be valued and respected and not simply discarded like yesterday's trash. Teresa Cunningham has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Kentucky, in Ohio, and across the United States. Her firm's goals are not only to get justice for her clients, but also to make sure that everyone is treated with equal respect and dignity as guaranteed under the Constitution of the United States. Teresa has built a substantial reputation by consistently winning cases other law firms have turned down. Her amazing courtroom skills and headline-grabbing success rate continue to provide her clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Florence, Kentucky. It is my great pleasure to introduce Teresa Cunningham to the show. Welcome to the show, Teresa.
Thank you.
Tell our audience a little bit about your law firm. What kind of law do you practice?
I practice employment and workers' compensation, and I'm a trial attorney.
Mm-hmm. And you specialize, I think, in cases representing individuals, right?
That's correct.
Only individuals?
Yes.
Okay. You could have chosen any type of practice. You could have represented major corporations like insurance companies, your favorites, right?
Right.
But you decided to represent the little people. Why?
I enjoy holding companies responsible, and I enjoy representing people who need a good lawyer to represent them.
Because
they appreciate you.
The legal system's kind of difficult. It's a difficult journey to make.
It's very difficult.
Yeah, and if you don't file the right forms, fill out the right things, make the right motions, you are out of luck, aren't you?
Right, and you have to have an attorney that's passionate about your case, because it's a lot of work.
Yeah. Today we are here talking about a specific case which originally started out as a age discrimination case. It was a wrongful termination case, and the two clients, one was your dad,
yes,
and another one was his friend, Alex Pennington. Tell our audience a little bit about these two men and why you got involved and what happened.
Both men worked for Litton Industries for quite a few years. I think my father had been there around 30, and Pennington maybe 30, 35, or 40. Litton had laid off 200 people in a series of layoffs, and my father was absolutely convinced it had to do with age and or his pension.
He was, what, 59 at the time?
He was 59. I believe Mr. Pennington was 60.
Yeah, and they had worked for the company for something like almost 30 years.
Right, Mr. Pennington had worked for them since 1956.
Yeah.
And my father had worked for them since 1966.
Yeah.
And they were laid off in September of 1993.
When they were laid off, your dad was convinced that it was because of his age.
Right.
And he came to you, and there's problems when you pursue a case like this, aren't there?
Oh yes, well, one of the difficulties is the defendant has all of the evidence. So when a plaintiff first comes to you, you have their version of what happened.
Yeah.
And that may or may not be the truth, that may be their perception.
Right. So you filed suit. It was about a...
He first filed with the Equal Employment Opportunity Commission,
yes,
as you have to do if you're going to go into federal court in Kentucky. And they came back with the no probable cause. I then took 10, in fact I had 10 plaintiffs that had been laid off. I took them to another attorney because I really didn't want to represent my father because of the personal connection.
Yes.
This other attorney refused to represent them on a contingency basis. And I refused to allow my father to pay this individual hourly, because he had been laid off making around $12,000 a year in retirement.
Yeah. Now you brought up something. You said when they filed with the EEOC came back, and usually they take up to a year, don't they?
Yes, you can ask for a notice of right to sue after a certain amount of time, but you have to have that notice of right to sue before you can file suit, and then you must file within 90 days of receipt of that.
And the EEOC, in his case, came back with no probable cause.
As they do in many cases.
What is the disadvantage of that kind of a ruling, if any?
From my perspective, there's no disadvantage or advantage. The EEOC comes back with very few probable cause, and the defendants are going to fight you tooth and nail anyway. So, and it's not allowed into evidence, so...
So why bother go with the EEOC initially? Why bother at all?
You're required to. You have to file with the EEOC to get into federal court.
Yeah, so let me get this straight. You have to file by law. You have to go that route. But really it has no meaning whether they come back positive or negative, correct?
My understanding of the reasons behind it is they're trying to get cases to resolve before they go into federal courts. It's such a large number.
Yes.
So you're required to do it. You've got very short deadlines. A lot of people miss deadlines. If you miss those deadlines, you're out. The advantages of it actually are that once the case is closed by the EEOC, the plaintiff can get a copy of their file, and that way you're provided with the defendant's answer and their defenses as to why they did what they did.
So in other words, that's really kind of the only way you can get that information, because the government requires them to file it.
Well, I had another case where the defendant just didn't respond to the EEOC, and the EEOC has no contempt power. So defendants sometimes don't respond, but if they do, you can get that documentation, review it during that 90-day window, which will give you a better idea. But then you're also allowed to pursue discovery through the civil process to go into more detail and get more information.
What were some of these specific challenges and the hurdles you had in this case?
Starting from the beginning, these cases are difficult again because you don't know the defendant's side. You need to get witnesses who will testify on your plaintiff's behalf. This case was a little bit easier because they had laid off 200 people, and people were coming forward. People were coming forward to be a witness. They gave me documents, so that helped. But in these type of cases, you have to prove intent. So it's almost as hard as fraud. This is very hard to prove someone's intent, and just because you're a certain age and you get laid off or fired doesn't mean that it's age discrimination.
Right. What are some of the other elements you have to prove? If you're older, you got fired, how do you prove age discrimination?
You have to prove that they're going to come up with a legitimate reason for why they chose you to fire you, and you have to rebut that. You can't just go in with what they call a prima facie case. I mean, that will get you over the first hurdle, but the burden then shifts to the defendant to come through with a legitimate reason, and then you have to come forward with more evidence to rebut that. So if they say you weren't doing your job satisfactorily or whatever reason, you have to come back with evidence that says, no, I was. You essentially have to prove they're lying. That's the only way you're going to win these cases.
Right. And you do that by getting the evidence that you need to rebut exactly what their defense is, correct?
Right.
In this case, you had kind of an advantage because you had 200 people that were laid off, correct?
Right.
And you had many of these people were willing. Did they come forward and testify, provide you affidavits, what?
Several provided affidavits, several came forward and testified, and without those co-workers testifying, because my dad and Mr. Pennington, one of their defenses was, hey, they weren't doing their job. So we had previous supervisors come in and say, but I didn't have a problem with his work for 10 years previous, so why all of a sudden now is he a bad employee? Right.
If I was on the defense side, I'd say, well, you know, the guy was a great employee for 10 years and all of a sudden he started drinking or he started womanizing or whatever. Right. I'm sure they bring that up, right?
Oh, yes, sure.
In other words, whatever you did in the last 10 years doesn't guarantee tomorrow you're going to be the best employee, right? But if a jury looks at that and they say, well, you know, if somebody was an excellent employee, they had excellent performance reviews, it's kind of improbable that within 6 months after a new supervisor came in or after a decision came down, that they would totally alter their personality. In this particular case, you were able to show that the employer had a specific plan to lay off older workers, right?
Right.
How'd you get that information?
We got some of it through discovery and some of it by witnesses bringing it in. In fact, it's in the decision that the HR department wanted to save money. They'd come up with a list on high-risk people, outlining their health conditions, whether or not they'd had children, they'd ever sued an employer before, and that sort of thing. Which, by the way, the court said was perfectly okay because companies have the right to determine their risk, if you will, their liability.
Now, eventually, the age discrimination element of this case was thrown out, right? But tell our audience a little how you won specifically, because I found that rather creative.
We had added a claim for ERISA, which is it's an interference claim where you show that a company purposely interfered with the plaintiff's right to obtain benefits, be it health benefits or pension benefits.
Right.
And when I first took the case, I did not see any evidence that supported the fact that they had interfered or wanted to interfere with my father and Mr. Pennington's pension benefits. But as the case developed, they did things like they laid people off but hired them back with no benefits.
Right.
They came out with a list.
That shows intent, right?
Right. Well,
Okay.
it leads to it's circumstantial.
Yeah.
So the judge or the jury can infer that was the intent. We came up with documentation of how much my father would have saved them or did save them by being gone. I think his pension contributions were like $7,000 something a year. Mr. Pennington's were $2,000 and something. Plus, we came up with a document that showed that they had put together that showed they saved, I believe it was over $12 million on benefits based on the people they had laid off.
And we were talking about this before the show. The process of, when you say we came up with this document, how long did it take you to get that document?
It took years.
And what did you have to go through, too?
In the discovery process, you send requests for production of documents.
Yeah.
And a lot of defense attorneys play the game that, well, you have to specifically ask for
So if you
the
didn't
document.
ask specifically for this one particular document
Right.
that had a number 1 in the right-hand corner, we don't have to give it to you.
Right.
What does the judge do in cases like that?
You have to prove to the judge that you need it, and
Yeah.
they have it. And it's a hard thing. I had employees kept coming to me and talking about this letter from Joe Beebe, who was the vice president of the division. And I'm like, what are you talking about? My dad kept mentioning it. So I specifically, and one of the IT people came forward and said, hey, ask for Mr. Beebe's computer backup files.
Yeah.
So I sent out a request for production of documents specifically for that. And to the other attorney's credit, I will say, he was very honest about this. He produced a stack probably a foot tall of documents, and in that stack was one letter that said something to the effect of, there are 4 senior project engineers that we believe can provide us liability based upon their age and longevity with the company.
Yes.
And my dad was a senior project engineer.
Right. Now, you eventually won the case.
Yes.
Tell our audience the verdict.
Well, it was,
For your dad, I think it was $391,000.
I think it was like 348 or something.
And for
Pennington,
Mr. Pennington, it was like 151 or something like that.
something
right?
to that effect. Total with the interest in this one.
Yeah. Now, you got a verdict, and this is why we do these stories. What happened next?
The defendant refused to pay.
Well, when you say refuse to pay, did they appeal it, or they just said, we're not going to pay it?
Well, they just didn't say anything. And then
Yeah.
you got that 30-day window. They filed a notice of appeal.
Yeah.
And I made them post a supersedious bond.
Yeah.
So they
And
did that.
the purpose of that, so our audience understands that, is that they have to put up money, right?
Right.
They don't like putting money up, do they?
Right.
Yeah.
Right.
But you're putting up a bond because you're saying, hey, if they really want to pursue this legitimately and they really are serious, they're willing to put up money.
Right.
Right.
And they went through an insurance company, put up the bond. Then we had to go through the appellate process in the Sixth Circuit.
Yes.
And once we won that, they still refused to pay.
Okay, so now the appellate court says you got to pay.
Right.
And Litton Industries and all these other people, they refuse to pay.
Correct.
What do you do next?
I filed a motion with the court to get a court order forcing them to pay. A federal judge has a lot of power.
Yeah.
And I even had to bring in the surety as a party.
Bring in means you had to list them now.
Right.
They're liable too.
Right.
Okay, and they didn't like that, did they?
No.
So they eventually paid.
Well, they didn't file, I think they got a stay until they had filed for cert with the U.S.
Yeah.
Supreme Court, which was another,
Right.
delay.
So in these cases, the reason we're discussing this, from the time that your dad was wrongfully terminated and Mr. Pennington was wrongfully terminated to the time you finally got paid was many, many years.
Yes.
9 years, 10 years?
He was laid off in 1993.
Yeah.
If I recall correctly, they got their money in 2000. And then I wanted interest on it. I wanted my attorney's fees.
Yeah.
Then we went through the whole attorney fee process. I got paid my attorney's fees, I believe it was 2001. And then I wanted interest.
Yeah.
And I wanted to be paid for all the appellate work
So it was
I
like
did.
8 years.
The final check, or the final order, came out in 2003.
Yeah. So, one of the things we like to point out is it's a long road to get justice.
Yes,
And it's a tough road.
and the plaintiffs have no money coming in during
Yeah.
this time.
And that's another thing. Usually they're blackballed. They can't get another job because this is in the newspapers maybe, or employers talk.
Right.
And it's a big disadvantage. So let's talk right now a little bit about some frequently asked questions like age discrimination. What is age discrimination and how do you prove it?
Age discrimination essentially is when you're treated differently than younger employees.
Yes.
But to prove it, it's not just enough that you're older and you were fired or you were laid off. You've got to rebut, again, those legitimate reasons.
Yeah.
Well, we fired him because he wasn't performing correctly. So you have to come up with that additional evidence that shows, no, I was a good employee.
Yes.
Here's my evaluations, and have documentation. Nothing speaks better than documentation. And you have to prove the employer was lying.
Right. Was there ever a point in time in this long trial that the defendant offered to settle the case?
Yes, the judge had a settlement conference, and they offered to settle for, I believe it was $20,000 apiece.
$20,000.
Yes.
It's kind of a nuisance settlement, right?
Yes.
If a person thinks they've been discriminated against, what should they do?
Find a good lawyer.
Find a good lawyer and gather as much facts as possible.
Right.
What about being wrongfully terminated? What is the definition of being wrongfully terminated?
Wrongfully terminated depends on state law.
Yeah.
I know in Kentucky, if you violate a contract or public policy, that's a wrongful termination.
Yes.
I think in the general public sense, it's any time you're fired for an incorrect decision.
Mm-hmm. Mm-hmm. And last question, how do you select cases and your clients? Because you have a lot of people call you.
Right.
And probably half of them really don't have a case. But how do you make the determination? Because I want to point out to our audience that lawyers like yourself do not charge people to take on a case. So when you're looking to take on a case, you're looking, how long is this going to take to prove?
Right.
Based on your experience.
Right.
And do I have a good shot at winning?
Right.
So how do you select your clients and your cases?
Well, like you said, I do most of my practice on a contingency basis, so I am not paid until and if we win. So when the client comes in, I want to make sure that they're very committed. I want to make sure that they're very clear with what happened. I want to see documentation, and I want them to be someone that is committed.
Yes. Committed means willing to go the whole route, which may take years.
Yes, and understand there is financial responsibility too. Even if I do it on a contingency, they have expenses, they have filing fees, you know, expert witness fees, deposition fees.
And it costs a lot of money.
Yeah, and unfortunately, a lot of people just can't afford to litigate.
Yeah. Most people who come to you have never sued anybody in their life, and most people are adverse to being in a courtroom proceeding anyway.
Right.
Well, I want to thank you very much for being on our show. I might also mention that you're running for Supreme Court judge in the state of Kentucky, correct?
Yes, I am.
And we wish you much success. I'd love to see you on the bench because you bring an air of quality and, you know, straight-mindedness that our system needs.
Oh, well, thank you very much.
Thank you for being on our show.
You're welcome. Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.